Well, good afternoon, everybody, and welcome to the Samfiru Tumarkin live employment law show. My name is Sandy Chen. I'm an employment and disability lawyer at our firm's Vancouver office. I do these live shows every 3 weeks, and I'm just here to answer any questions related to employment law, related to maybe disability law, related to any issues of discrimination. So I'll be here for the next half an hour or so answering your questions live. So don't be shy. You can type your question into the text box, and I'll be able to see it in front of me here. And I'll do my best to answer the questions as they come in. I find that sometimes the questions are more complex and need a bit more detailed conversation. And so I'm happy to chat with anybody privately afterwards, or if you can reach out to me on our website. I'm happy to have a consultation with anybody if that's needed. So if you're having issues at work, if you're having issues with your boss, any bullying, harassment, discrimination, issues to do with your severance pay, or issues to do with your medical leave or anything like that, here's the place to ask those questions, and I'll do my best to answer. One of the most I've seen a range of issues come across my desk in the past few weeks or so. One issue I've seen is about corporate takeovers and acquisitions and the impact of that on employee rights. I've seen that come across my desk a few times now. And so it's important to remember that when you have a new company taking over your employer, sometimes they will get you to sign a new employment contract. What I will say is, there's a lot of things I could say, but what I will say is it's very important to have an employment lawyer review that contract before you sign it. One of the critical things that I can think of is recognizing your previous length of service, right? Or reviewing that contract for what's called a termination provision, right? How much your severance will be if the new company decides to let you go. Also, your new job duties and responsibilities. And so I've had one consultation where the company was taken over, and all the employees of the old business got new contracts. And in that contract, there were a lot of terms that were, let's call it, unfavorable to the employee. So you would have things like non-competition agreements, non-solicit agreements. Excuse me. You have things like, we're only going to pay you the minimum severance possible if we ever let you go, even without cause. And so things to watch out for in that situation. I see we have a few questions here. So we got our first questions from Lyle. You have multiple questions. What about hours worked over contracted salary? Yeah, Lyle, so that's a good question. So, I've had some people. I've had consultations with people, and my understanding is that there's a belief out there that if you're on salary, you don't get paid overtime, right? In BC, as well as many other provinces in Canada, that's not the case, right? You are entitled to overtime pay even if you're on salary. In BC, how you would crunch that number is if you get $40,000 a year on salary, right, and you work 40 hours per week, well, you can get an hourly wage for that. And so, if you work 41 hours for a week, you're entitled to that extra hour of pay that you worked based on your hourly wage when you crunch that number. If you work over 8 hours a day in BC, you get overtime pay, right? If you work over 40 hours a week in BC, you also get overtime pay. And the overtime pay would generally be 1.5 times your hourly wage. So, yeah, I mean, you should get paid for the hours you work above your salaried contracted hours, right? And so if your salary is, whatever, 100,000 for 30 hours a week, you would get paid for any hours you work over your contracted hours. And overtime rules apply after certain hours of work. So hopefully that answered your question. If you have follow-ups, and this goes for anybody, if you have follow-ups, please just type it in. I'll go in the order that I see them. Next question is from Maria on YouTube. Can you use a recording you have of your boss lying in a meeting with HR? Yeah, Maria. So the issue of recordings. It actually comes up a lot in my practice. It's usually, I will say, okay to use a recording, and I assume when you say use recording, you mean use it for court purposes, right, or some sort of legal proceeding against the employer. So there's a few different issues when you're recording. If you're part of the conversation, right, it's not criminal to record it. But if you're not part of the conversation, if you stick a recorder in a room, right, and you're just recording a conversation of HR, maybe your boss, that's not allowed, right? The second issue you have to consider is, do you have a good reason to record the meeting, right? There is a recent case out of BC where the employee, I think, he must have made over 100 recordings of just random meetings or presentations throughout his years as an employee with this company. And what the judge said was essentially, you really had no good reason to make these surreptitious recordings, and so because of the recordings, the employer has just cause to terminate your employment, which means, and that means obviously you're let go and no severance pay is owed to you. So you have to be careful with the recordings because it can backfire, right? If you make recordings for no good reason, you're just recording secretly for purposes that have nothing to do with stuff like bullying, harassment, or your boss lying, then a judge could find that breaks the trust between you and the employer. And I think you can probably understand why that is, right? The employment relationship is generally based on trust, and if you secretly recording all of your colleagues' conversations without their consent or knowledge, that does break down the trust, right? Now, in your situation, Maria, it sounds a bit different, right? If your boss is lying about you, or about your performance, or making unfounded accusations of you to build a case against you with HR, that's a different situation, right? I think in that case, a court would be more likely to find that you had a valid reason to record, right? Because you were being targeted at work, or something bad was happening to you at work, and so you just wanted to kind of have the evidence there to prove it, in case you need it. And so there's some issues, and then there's another issue of whether the recording's actually admissible in a courtroom. But we don't need to get to the legalities of that, Maria. I think for your purposes, if something's up at work, if something bad's happening at work, I would say generally it's okay to record as long as you're part of that conversation, right? And don't, from your question, hopefully you're a part of it, that conversation of your boss lying in a meeting with HR. If you're just sticking a tape recorder in a room and you're not there, right, that's not allowed. Okay, so we'll move on to the next one here. Question from Bryce. So Bryce, you just put in 2 weeks notice after 5 years with your employer. You thought this was amicable, but the next day, all of your shifts were cut from the schedule. Do I have to accept the loss on 2 weeks worth of work here? Yeah, so Bryce, that's a good question. So the short answer is no. Okay. If you give notice generally, and the employer, the company says to you, we're going to stop your work on the first day of your notice. that is likely considered a termination of your employment, right? And what happens is if it's a termination, then you're entitled to severance pay, right? And so in most cases, an employee severance pay is a lot greater than 2 weeks. So I would say in your situation, they may have made an error by, you know, ending your notice, your resignation notice early and cutting all your shifts and not paying you. That's likely considered a termination, which now entitles you to severance pay, right? And severance pay, as a lot of my regular viewers would know probably, it ranges, right? It depends on your age and your length of service, and the level of your position. It could be 1 or 2 months, could be up to 24 months, right? Depending on all those factors. So yeah, short answer, Bryce. No, you don't have to accept the loss. That's likely considered a termination at law and entitling you to severance pay. Okay. All right, we got another one from Lyle. You're asking, you're in Alberta. You're contracted 120 hours of pay period for $145,000 a year with 230 hours plus accumulated. You were being denied access to the funds or time in lieu of as per the contractual agreement. Okay. So yeah, Lal, if you could clarify your question a bit. So I assume a pay period is that 2 weeks? Is that bi-monthly or monthly? If you have 230 hours accumulated, I assume that's maybe an overtime bank or some sort of vacation bank. If you have those accumulated, they have to be either, or you can agree with the employer to have it as vacation or paid out to you as overtime pay, right? At the overtime rate, if that's applicable. So I will say to you, I mean, I'm not. I obviously don't practice in Alberta. I'm in BC. The Employment Standards Act might be a little bit different there, but I think the general rule is if you are contracted, let's say $145,000 a year to work 40 hours every week, right? And you work 50 hours or 60 hours a week. Yeah, I mean, you would be entitled to pay for those wages. For those hours. There's some exceptions in terms like certain professions or certain occupations have special rules, exemptions. So, for example, me as a lawyer, I'm not covered under the Employment Standards Act, right? Or there's certain special exemptions or regulations for, fishermen or truck drivers. And so your job does matter too. And so, maybe just clarify, Lala, are you saying a pay period, is that every 2 weeks or is that monthly? When you say 230 hours accumulated, what does that mean? Is that just in an overtime bank or what is that? Okay, we got more questions. Got a question from Icy. You were let go from a seasonal job at a summer camp. You were hired on contract for the entire season, but you were let go because it wasn't a good fit. They're telling me that because I am on contract, I am not owed any severance. This is accurate. Short answer, it's not. It's not accurate. If you have a contract, and it sounds like in your case, it's if it's an entire season, I assume there's fixed dates of when your employment started or ended. If, let's say, hypothetically, if your contract was supposed to go to October 1st, right, but they let you go on September 1st, you should be paid out for the balance of that contract, right, the entire month. There's certain exceptions to that rule where, if there's something in the contract that says they can pay you less if they ever let you go, right? But the general rule is you're entitled to be paid out for the balance of the contract. unless something in your employment agreement says otherwise, right? Because the employment contract dictates what severance you're supposed to get. So no, it's not accurate. I mean, I would speak with an employment lawyer right away to see what. Well, come speak to me if you're in BC, but usually if you're on contract, you should be paid out for the balance if they let you go early. Okay, we got another question from Darren. He says, your painting looks very nice. Thank you, Darren. What happens if the company you work for is based and only has a presence in the US, and I'm working on US projects? Can I still get severance in BC? Yeah, that's a good question, Darren. I've come across that situation a few times. If you're, and I assume you're working remotely from BC, right? I assume you don't live or reside in the or work in the US. But if you work remotely for a company in BC, you still get severance, right? Now there's a question of if the company has no assets in Canada, right? If you sue this U.S. company for severance, and you get a court award for severance, and there's nothing in Canada to enforce that judgment, or if your employer has no assets here, there is a second step you would have to take of trying to enforce that judgment in the States, right? Which is a whole separate issue, which I won't get into. But just because you're a remote employee working for a U.S. company doesn't mean you know employment laws don't protect you here. The only issue is you're obviously enforcing that judgment if needed will get a bit more complicated if they're only in the States. Okay, we got more questions. So a few follow-ups here from Lyle. So you're saying you're getting paid bi-monthly, so you're working 120 hours bi-monthly, okay. So that means you're working 60 hours, or about 60 hours a week, and you've accumulated 230 hours in overtime banked. You're the chief operations officer, and you're saying that hours banked, it's at 1.5 the rate. Okay. Yeah, so I mean, so if your contract says 120 hours a pay period, right? So every 2 weeks or so, or bi-monthly, and you're working 150 hours bi-monthly every 2 weeks, then yeah, I mean, you should be paid for those hours, right? At the overtime rate. Although I'm not exactly 100% sure on the overtime rules in Alberta, because again, I don't practice there, but it sounds similar to BC. You being denied access to the funds, is that just you trying to get those paid out, or is that you trying to take vacation with them? In any case, it's a complaint you would make to the Employment Standards Board, right? In Alberta, obviously. If they're just being denied, and I don't know what reason they're giving you for it being denied, but those are earned wages, right? And it's if they're earned wages, it belongs to you. Yeah, and I'll just add, I mean, the employment standards process in Alberta, my understanding is you would just go online and file a complaint. But I would speak. I have colleagues in Alberta, in Calgary, that you can speak to about this situation. I would seek some legal advice before you proceed. But in my view, I think if they're denying this, your use of this overtime bank, it would be, well, first you should raise it with the employer, And then if they still don't do anything, you got to file employment standards complaint. But definitely speak to an employment lawyer in Alberta about it before you do anything. And I'm happy to connect you with one of my colleagues in our Calgary office if you like. Okay, so we've got a question from Devin. You've worked part-time at a retail store for the last 3 years. You're taking a vacation in August for 2 weeks. You told them in May. Okay, your boss told you you must resign and reapply when you return. Is this allowed? Yeah, Devin, that's a good question. It raises kind of a bunch of issues. So, in terms of whether it's allowed, I would say you don't have to resign, right, and reapply when you return. The if you're non-unionized, the thing is they can let you go at any time for any reason, right? As long as it's not illegal. And so it's allowed in terms of the employer can let you go, right, if they want, but it's not allowed in terms of the fact that they can't ask you to resign and reapply and not pay you any severance pay, right? And so just to I guess clarify that point a little bit, you do not have to resign. I would advise you not to resign and reapply. If the company wants to let you go, they're going to have to pay you severance pay, right? And then that's obviously their prerogative. They want to let you go, and this only applies to non-union employees, right? Because union employees typically the employer has to have just cause for termination if they want to let you go. So no, I mean, Devin, I don't resign, and if they want to let you go, they'll have to pay you severance. Okay, we've got a few more questions here. We got a question from Empire W. You have a new manager that you report to, and you do not get along. You brought this up with HR. Nothing's been done. The manager continues to target me. She recently gave you a PIP to sign, and the PIP's entirely false. Your performance before this manager came in was always rated highly. You're told that if you don't sign, you will be terminated immediately. But I'm worried that they're going to use the PIP to fire me with cause anyway. What should you do? Yeah, so that's obviously it's an unfortunate situation. It's a tough situation to be in, right? Because you're in a situation where your manager sounds like she's trying to get you out of there. So if the PIP is entirely false and they're just trying to build a case against you, right? There's a few things you can and should do. So number one, don't sign the PIP. What you should do is essentially provide a written response to your manager and outline why you disagree with the PIP, right? And why you are refusing to sign it, right? You're refusing to sign it because you don't agree with it. And then this is, here's the bunch of reasons why you disagree with it. If they decide to let you go for cause, obviously I don't know all the facts in your situation, but it is extremely difficult to let any employee go for cause because of performance issues, right? The employer has to show that they did everything possible to kind of coach the employee, give them time to improve, set objective, reasonable targets, right? And not these unrealistic, out of reach targets. And they have to be concrete things, right? It can't be just subjective, like, you should be friendlier, or you should be nicer to people, or stuff, or something subjective that's not measurable, right? And so the bottom line is, I guess, it's difficult to let someone go for cause for performance. There's a bunch of steps an employer needs to take to do that. In your case, if they do terminate you, and I assume this is your first PIP that you've been on, it's very likely that it's going to be a without cause termination, right? Which means that you are entitled to severance pay. The other way I would look at your situation is, do you want to be, do you just want to wait around for them to let you go, right? Or has the workplace become so intolerable? And I can imagine if your boss is just trying to if he or she is just targeting you and trying to get you out of there, it's probably very uncomfortable. And so instead of waiting for them to try to let you go for cause, you can claim what's called a constructive dismissal, right? Essentially, where you're essentially saying the company has fired you without explicitly saying that they fired you, right? Through the company's conduct, they have essentially terminated your employment. And so and the constructive dismissal is essentially the same as a wrongful dismissal in terms of what you can claim, right? You would be claiming for severance pay. So if the workplace has become really intolerable and toxic, you should speak to an employment lawyer before you quit and claim constructive dismissal, because the cases generally are difficult because you need to prove that the workplace was toxic, right? And so in your case, you'd have to prove that the PIP is false, obviously, right? And the manager is just targeting you for whatever reason, and the manager's trying to push you out of your job, right? And it's, in my line of work, I've seen it's unfortunate, but it does happen. And that's why our judges have kind of recognized that in these types of situations, you can't expect the employee to keep working in these conditions, right? So yeah, I mean, to answer your question, there's a few things you can do, but I think the first thing you should do is seek or talk to a lawyer privately, right? Get into the details of what's going on in your situation, and then assess what the best next steps are. Okay, we've got more questions. We got one from Carol. Does a 70-year-old collecting CPP qualify for severance if totally disabled? So your mom does not have LTD. She's currently on EI disability, would not be able to return to work. Her boss says they will not be able to accommodate her. Does she qualify for severance? Does age play into it? Yeah, so that good question, Carol. There's a bunch of issues there that we probably can't get into, but let me kind of give you the general breakdown. So if you're totally disabled, right, and that's a legal definition under a long-term disability policy, meaning you can't work, and the company lets you go while you're on disability, you should be entitled to severance, unless the only exception is if there's no reasonable foreseeability of you going back to that job. So if you are a truck driver, right, and God forbid you lose both arms and legs, right, that contract will probably be considered to be frustrated, right? What that means is it's not, it's kind of not your fault you can't do your job, and it's not the company's fault you can't do your job. You have, obviously you've lost the ability to do the job. And so in that situation, severance probably is not payable. Conversely, if you have a situation where someone's off for mental health issues, right? And a year into their medical leave, they're let go. Arguably, there's a reasonable chance that person would have returned sometime in the future, right? Maybe recovered from their mental health issues and went back to work. And so that's a very different situation than the truck driver example I just brought up. And so it's a question of kind of, why are you off work? How long are you going to be off work? And is there some foreseeable chance that you're going to be able to return to work? And so the second issue your question raises is this issue of accommodation, right? So failing to accommodate an employee with a medical condition could be considered a discrimination under the Human Rights Code. And so, putting the issue of severance aside, you could get compensation for discrimination if the company doesn't accommodate your mom and decides to let her go. Um, you know, you had said your mom will not be able to return to work. I guess the question is, for how long, right? Is this a permanent thing, or is this kind of a temporary um, time period where your mom just needs some time to recover? And so, and to your last question, does she qualify for severance? As I've explained, she could, right? Just because she's on this disability doesn't disqualify her for severance, or does age play into it? Yeah, I mean, age does play into it in terms of, the older you are, the bigger your severance package should be generally, right? A 65-year-old should, other things being equal, get a bigger severance package than a 23-year-old. And that's just based on the assumption that it's harder for older employees to secure another job after they've been let go. So hopefully that answers your question, Carol. And I think I got to everybody today. But I will be back in 3 weeks. I do these every 3 weeks on Thursdays at 1 p.m. And so if I've missed anything, my colleague Dan Balkarin is here tomorrow at 10:30 a.m. Pacific time. So please be sure to ask him anything that I've missed. But yeah, thanks everybody for coming, and I will see you guys next time.